Let's go ahead and get started. It's the House, wow, very blurry. House Judiciary Committee, it's Thursday, February the 2nd, a little after 2:30. We have 3 whole bills. Oh boy, how long will this take? I know. Okay. Yep, it's jinxed. So, Delegate Long. No Delegate Long yet? All right. Well, I know that Delegate Williams was just here. I just finished talking to Delegate Williams. Okay, I think we're going to delegates. Are you ready?
Well, I would be if I had my...
See, this is what happens when we only have 3 bills, is nobody comes when they're supposed to be here. This is terrible. Move unfavorable. That's right. Oh, wait. Are you ready to go, or do you need a minute?
I did a little bit, I'm okay. That's all.
You need a minute, or do you?
I think I have my, oh, it's my first.
For all of you at home, welcome to the Judiciary Committee. You were second, but we don't see Delegate Long.
Yeah, that's why I thought I had a minute to.
I know.
Okay, well, I'm ready.
Do we know what, well, wait a minute, do we know where Delegate Long is, or do we?
I haven't seen him. I'll check.
You know what, that would explain his text message to me.
Somebody want to call?
He is here. I thought,
He needed to be down here, and I didn't know what he was talking about.
oh dear. Well,
Oh,
this is Robert Long.
okay, different.
No, it's Jeff Long.
Is it Jeff Long?
This is Jeff, but his first initially is
Okay, is he coming?
we have reached out to an office.
Okay, I'm sorry, Delegate Williams, we're gonna need you to go. If you don't mind. This is a well-oiled machine here.
All my witnesses are here, but yeah, I'm ready.
Well, let's see if your witnesses are here. Yeah, there's one witness who's here. Ms. Trivedi, correct? All right. And then Natasha Kalfani is here, great, okay. And I'm gonna keep talking a little bit to give Nicole some time. And then, do we have Alexa Richardson on the tube? Okay, oh, there she is, that's fine. And Kristen Weinstein is there, and that's fine. Ms. Weinstein, you're indicating you're favorable with, whoops, there you are. You're favorable with amendments, is that correct? Or are you just favorable of the bill?
Favorable of the bill. I apologize.
Oh, you're favorable of the bill. Okay, so we're gonna put you as part of the first group. I see Mr. McCutcheon as well, so we'll be fine with that. We'll need Ms. Richardson back on the screen in a moment. What we'll do, now that we're settled, Delegate Williams will go first for 3 minutes. We'll hear from the 2 people who are here, then the 3 people who are here virtually. Each of them will get 2, and now that we've gone through all of that, Delegate Williams, please, for 3 minutes.
All right, good afternoon, Chair Clippinger, Vice Chair Moon, and the members of the House Judiciary Committee. I am Delegate Nicole Williams of District 22 and testifying in favor of House Bill 232, also known as the Child in Need of Assistance Neglect Marijuana Use. This legislation would change how cannabis is used by parents, is viewed during child in need of assistance proceedings. The use of cannabis by a parent will not serve as a reason enough by itself to separate a child from his or her parent unless additional findings were proven that the child is actually in danger. This legislation comes at a time when attitudes towards cannabis use are shifting across our country. And as of right now, 39 states allow cannabis use for medical purposes, 23 states have fully decriminalized possession, and 19 states have legalized recreational use for adults. At least 15 states already provide the similar child custody and visitation protections which are covered under House Bill 232. And this encompasses individuals participating in the medical program or for recreational use once we go there, if we go there, once we get there. Here in Maryland, the possession of small amounts of marijuana currently has been decriminalized, and a full-fledged system has been developed to sell marijuana for medical use. And as we have the conversation to pass legislation out of House to move towards full legalization, we should also have this conversation about the impact that cannabis use plays in the child in need of assistance cases. These lingering restrictions regarding cannabis possession and usage have, in the words of the American Medical Association, disproportionately and adversely impact marginalized and minority communities. Cannabis use among Black and white individuals is roughly the same, with some estimates reporting slightly lower use amongst Black populations. Yet, according to a 2020 study from the ACLU, Black individuals were 3.64 times more likely to be arrested for cannabis possession. These disparities also exist in legal proceedings like Senate cases involving neglected marijuana use and often cause irreparable damage to the structure of a family. A parent's cannabis use alone should not determine their ability to care for their child, and separating families simply based on cannabis use exacerbates trauma and anxiety for both the parent and the child. This long overdue legislation will help to change the culture around cannabis, and for these reasons, I urge a favorable report on House Bill 232.
Thank you. Good afternoon. My name is Natasha Calfany. I'm the Assistant Director of Government Relations for the Office of the Public Defender, and I'm asking for a favorable report for HB 232. As Maryland addresses issues of legalization and decriminalization of cannabis, we must simultaneously address the negative impact cannabis has on parents who use. Marijuana has been used as a tool to allow government intrusion into the lives of people who are fit to care for their children. In the circumstances of pregnant persons using marijuana, even prescribed, cannabis use will at minimum result in DSS investigations and at worst could lead to removal of an infant, regardless of the mother's ability to care for the child. For parents facing allegations of abuse or neglect for other reasons, if it is learned through investigation that a parent uses marijuana, at a minimum, the parent is required to complete drug assessment and drug treatment. But children are often removed from the parent's care until substance treatment is complete and the parent has documented 90 days of sobriety. If a child is in foster care and a parent has complied with all court-ordered services but continues to use marijuana, that parent will be denied unsupervised visitation and denied reunification, even if the parent has remedied all other issues that brought the child into foster care. There is case law that says there has to be a nexus between parents' drug use and harm to the child. That rule is often ignored. Marijuana is not a parenting test, yet its usage is often a determining factor in whether a parent is able to provide proper care and attention. This issue, as you heard, also has racial implications that mirror that of the criminal system, in that the same unequal surveillance and policing that results in Black people being arrested for marijuana possession at 3 times the rate of white people, despite the same rate of use, also draws families of color disproportionately into child welfare. And for those reasons, we're asking for a favorable report.
Hi, good afternoon, Mr. Chairman, Mr. Vice Chair, and committee members. My name is Shanta Trivedi. I'm a faculty director of the Meyerhoff Center for Families, Children, and the Courts, and I'm a professor at the University of Baltimore School of Law. I write extensively on the negative impacts of family separation, and I'm also a parent. I urge you to issue a favorable report on HB 232. As you know, HB 232 clarifies that in order to be considered neglect, parental marijuana use must cause harm to the child. Currently, the stigma associated with drug use brands parents who use marijuana as unfit, even if there is no evidence of negative impacts on their children, and even if their children are not even in their care at the time because they're in the system. Children are prohibited from reunifying with their families, they're denied visits, or they're unnecessarily removed. And being removed from a parent is one of the most traumatic experiences that a child can have. Among other things, children suffer grief, anxiety, and post-traumatic stress disorder. When the president of the American Academy of Pediatrics explained that separating children from their parents permanently changes their brain architecture and contradicts everything we know about what is best for children's welfare in the context of family separation at the southern border. That the same is true for children here in Maryland. Yet in the name of child welfare, we separate children from their fit parents because we place moral judgment on them. And most often this judgment falls on low-income parents and parents of color. And we know that putting children into foster care is not always a better option. Studies detail the long-term horrific outcomes on these children. And right here in Maryland, we currently have children staying in office buildings and in hotels because we don't have enough placements for them. Multiple organizations recently filed a class action lawsuit against DHS here in Maryland, accusing them of over-medicating children with psychotropic drugs with limited oversight. Many of these children should not be in foster care in the first place. We are unnecessarily removing children who could safely be with their parents. And when caseworkers are forced to monitor too many families, serious cases that actually need their attention fall through the cracks. For those reasons, I urge you to support HB 232, and I thank you for your time.
We're going to hear now from, let's go with Philip McCutcheon, then Ms. Richardson, then Ms. Weinstein. Mr. McCutcheon, please unmute yourself. You've got 2 minutes.
All right, how you doing? Good evening, everyone. My name is Philip McCutcheon. I'm against it because for 6 years I've been fighting for my son. Everybody was against me, saying what marijuana would do, how it would react, sending me through these ups and downs, causing me to lose jobs, and basically making my life harder than what it was behind these things. But the moment I got my son, there was nobody there to help me, to lead me forward, to even give me the proper documents so that I could help my son or help me with my son and getting my son back. I'm just against it. I don't really see the benefit of taking someone's child away for something like that because it's a very painful experience. I wouldn't wish on anyone, and I wish I would never have to go through ever, or anyone else and ever have to go through ever again. That's all I gotta say.
All right, thank you very much. Hang on in case people have questions for you. Let's go to Ms. Richardson now, please.
Thank you, Mr. Chairman, Vice Chairman, members of the committee. My name is Alexa Richardson, and I'm an attorney in the Parental Defense Division of the Office of the Public Defender and a certified professional midwife. Testifying in favor of HB 0232. In considering this bill, I urge the committee to take account of the severe and known harms to children of being separated from their parents. At the Public Defender's Office, we often see new babies and young children being removed where a positive tox screen at birth for cannabis use is a contributing factor for the removal. Early childhood is incredibly significant for a baby's neurological development. Babies learn quickly to attach to the sound of their mother's heartbeat and voice, to her smell, and to that of other parents. During this time, babies are establishing their secure attachment, and current studies are clear that separation of an infant or young child from the parent is a major psychological stressor for the child. Even a few weeks away from a parent is an enormous amount of time for a child under 2, and as we see, the SINA cases take much longer than that to resolve and get parents reunified with their children. Cannabis use by a parent in no way poses the risk of harm to a child that separating a child from its parent does. Some of the documented results of separation of children include developmental regression, difficulty sleeping, depression, acute stress, higher levels of aggression, long-term chronic medical conditions like cardiovascular disease, hypertension, obesity, and decreased longevity. Children separated from their parents in the first 2 years of life score significantly lower on IQ tests. They're nearly twice as likely to be arrested or criminally charged. And this separation is also traumatic for the mother and drives inequity in our state, particularly in low-income communities of color. In the Parental Defense Division, we regularly see cannabis use by a parent used as a factor to claim neglect of a child. I urge the committee to protect Maryland children from separation by removing cannabis as a reason to separate a child from its parents.
Ms. Weinstein, please.
Hello and good afternoon. My name is Kristen Weinstein, and I'm testifying in favor of House Bill 232. I'm a mother of 3, happily married to my husband, Eli Weinstein. We are both certified medical cannabis patients. Last year, when I was pregnant with my 3rd child, like many women, I suffered from hyperemesis gravidarum, a condition that causes excessive nausea and vomiting. After home IV therapy, a Zofran stomach pump, and numerous ER visits, I continued to use cannabis because it was the only thing that helped me keep food down. Even with cannabis, I only gained 7 pounds during my pregnancy. When I went to Carroll Hospital for prenatal care, I was upfront about my use of cannabis for medicinal purposes. I even reached out to the public defender's office, who introduced me to Dr. Mishka Turplin, who wrote a letter on my behalf to the birthing center explaining that it was safe use of cannabis. Nonetheless, the head of the birthing center at Carroll County Hospital and the hospital appointed social worker told me that I would be reported to Child Protective Services, and I was. The same state that granted me access to the medicine that investigated my ability to be a fit parent. Although CPS did not take my children away from me, the investigation caused me and my family extreme anxiety and emotional distress. I did not understand the purpose of causing my household the stress and despair of feeling like unfit parents when my use of cannabis was safe and responsible. I felt insulted by how I was categorized the same way a parent would if they were under the influence of heroin or cocaine. My baby was born perfectly healthy, weighing 7 pounds, 20 and a half inches tall, and has met all of her developmental and growth milestones since birth, and her pediatrician even labeled her as socially advanced. I wish I could have longer and list additional evidence that is clear yet ignored by many, but all I can end with is that I am urging you to pass this bill so that no mother or family has to experience what I did. I want to thank the committee for allowing me the opportunity to share my testimony.
Thank you all very much. We'll now take questions for this first and only panel in favor. If there are questions from the committee, Delegate Grammer to begin.
Thank you, Mr. Chair, and thank you for the bill. And I really agree generally with the basis and the premise of the bill. Like, I want to keep the government the hell out of my life. And I don't use cannabis, but I understand fully the story of the lady who shared her story. But if you read the bill, it essentially says neglect does not include cannabis, the use of cannabis, unless it's neglect. So I'm kind of struggling to see how this works. Can you walk me through one of these cases? Tell me maybe how frequently this occurs, and help me understand how this law is going to get you to where you need to go.
So essentially, this law would not allow the court to consider cannabis use unless the Department of Social Services can connect the parent's use of cannabis to the harm that they're saying is being suffered by a child. As it stands now, the Department of Social Services can use cannabis as an allegation in and of itself. A parent uses marijuana, and therefore that is neglect. So this bill is saying cannabis use in and of itself cannot be considered as neglect just because you have a positive toxicology. And this statute, if this became statute, it would actually be in line with case law, because right now case law says there has to be a nexus between usage and the harm. That is ignored for the most part in most courts. And so right now, if there is the presence of cannabis, we automatically jump to the child is being neglected.
Get that 100%. You know, someone's got to make the case that it's neglect, and that's what the bill says, but then it subsequently says the child's health or welfare is harmed or placed at substantial risk. So it's not neglect unless it's neglect. It seems to me that you put this in place and you have the same paradigm. They're still going to have to make the case. They're still going to be able to make the case. And even if you pass the bill, they're still going to be able to consider use of marijuana if it contributes to neglect.
I think this really just clarifies what the law already is. Nothing should be neglect unless it causes harm. That's what the law says. So if I had a mental illness and DSS said, you have a mental illness and your child suffers, they have to prove what the connection is between my mental illness and the harm to my child.
Right.
That's what the law says.
Right.
But what we see on the ground is what Ms. Calfany described, that it doesn't matter, that DSS is coming in regardless of harm to the child, even when the child is away and everybody knows that. The child is in foster care and the parent may have used marijuana while they were away, and they're still saying, well, the child can't come home because you used marijuana, even though there was never any harm to the child. So this is just a very clear statement to DSS and to the courts that that is not what is permissible under the law. There must always be a nexus. And because of the stigma that surrounds drug use and the assumptions that people make about people that use drugs, particularly those who are low income and minorities, it's an added layer of protection that you can no longer use this because of what you think drug users are and who you think they are as parents.
I get that 100%. When someone comes to a judge and says they're using marijuana, so you have to keep the kid away, does a judge accept that? Are they accepting that? They're saying, we see that the child is not there, they're using marijuana for medicinally, we're still going to take the child, is that what's happening, is that?
Yes, that's what's happening. And so even in cases where, as she stated, if the child is already in foster care and the parent is using, then the court is going to say, well, your visits have to remain supervised because we know at some point in your life you're using. Or the child can't come home because we know that you use, whether it's in the presence of the child or not. And often parents have testified that they use outside of the presence of their children when they're away from their children. And still, just because they've used, and often it's self-reported use, they are being denied access to their children.
Okay.
I think you also have to remember that marijuana, you may know or may not know that marijuana stays in your system for a lot longer than other drugs. So you could have used marijuana a week ago when your kids were at camp or your kids were at a sleepover. And if you took a drug test today, you would test positive.
Right.
So it really is restrictive on a parent's. A parent could be safely using in so many contexts and still test positive and have their access to their child limited in this way.
Okay, thank you.
Delegate Conway, then comments?
Thank you, Mr. Chair. Thank you, witnesses, for coming in to testify. Thank you, delegate, for bringing this bill. Under this bill, if cannabis is found in a newborn's system, what would happen? Let's say at the hospital when they're born, what would happen?
What would happen to the child or what would happen legally?
Yeah, what would happen to the child and legally? Would the child be separated from the mother at the hospital?
If a mother and or the infant test positive,
Yes.
right now, what would happen is that the Department of Social Services would be contacted, just as you heard, and an investigation would be done. Under if this law were to pass, then it would be the same thing. If the marijuana negatively impacted the child, then the Department of Social Services would be contacted. But as you've heard from testimony today, that a mother can use marijuana medically and there be no exposure to the child, no harm done to the child, and the Department of Social Services is still called.
Right, that wasn't my question. My question was, if the baby is found marijuana positive, would the baby be removed from the parent's care? That was my question.
We can't say for sure.
Under this bill.
We can't say for sure that the child would be removed. We can't say for sure that there definitely will be an investigation.
Okay, thank you.
Thank you. So how does DSS or the judge know of the cannabis use? Is it if they've been charged or convicted with some kind of cannabis related crime, or I mean, how do they become aware, DSS or the judge?
There are so many ways. I mean,
Yeah, I mean, can you just like
Yeah,
throw
it
some
might
out
not
to me?
necessarily be criminal at all.
Yeah.
Or, maybe the parent is in the system already, they're coming in just to do but they're coming in to do a scheduled home visit, and they simply see cannabis sitting on the table, for an example.
Okay, can you give
Right.
a couple more examples?
Well, so there are no parameters around DSS investigations as there are in criminal investigations. So if a CPS worker shows up at your house, oftentimes clients are self-reporting because they don't know that could lead to removal. So just in conversation, do you use marijuana?
Okay,
If
so
they
I'll
say
ask
yes,
them. Okay.
yes. If they say yes, oftentimes even beyond that, they'll be asked to take a drug test on demand. And if parents are not aware of their rights, they're trying to comply, so they will keep their children. If they take a drug test on site and they test positive, again, now it's known that marijuana usage is prevalent.
I don't know if it's helpful to understand the scope of a DSS investigation. It starts from, the minute a phone call comes in, someone comes to your door and they say, open the door. Parents don't know what their rights are. We also have a bill, if anyone's interested in sponsoring, that would provide parents with their rights if DSS shows up at your door. Because parents don't know, and they are told, cooperate or we will remove your children. So they are told, let us in. If they smell marijuana, if they see marijuana, they're told, we're gonna have a meeting where we talk about a plan to figure out how your child will remain safe in your care. And they're told, take a drug test. It'll be better for you. They don't have counsel at this stage. So no one is telling them, you do not have to take a drug test. There's no court order that says you have to take a drug test. They ask them, do you use marijuana? And they self-report. And then once you're in the system, you could have a court order that says because we smelled marijuana on you one time, we will drug test you once a week for the rest of this investigation, which literally could be years.
Okay. Thanks.
Yeah, and just keep in mind, like a positive drug test does not mean they're currently intoxicated.
Right.
Yeah. Okay. Appreciate it.
Not gonna totally recognize the pages again, but I just would note the pages keep coming back to this committee. I don't know. I think it's exciting, really. I mean, we must be doing something right. Delegate Simmons.
Just dealing with general CPS upon being called or being alerted by agencies or individual. Do y'all find that most people are considered guilty to proven innocent when it comes to the immediate action that is taken by a CPS worker?
Absolutely.
And that lies where the problem is, the disconnect there. Just kind of going back to what we was talking about with the hospitals, right? So under current law, if a hospital determined that there's an issue with a parent, they automatically are required to notify social workers who in turn will take action on a parent until it's proven, would you say?
Yes.
Otherwise?
So once, you're right, hospitals are mandated reporters.
Right.
And so once they decide that there is an issue, however they come about that information, they contact DSS, and again, DSS immediately starts an investigation.
Have y'all been made aware of any situations where a parent has been separated from a newborn or been under supervision in a hospital as a result of those kind of complaints?
Yes, we get those cases all the time.
All right, thank you.
Thank you, Chairman. Thank you, Delegate Williams and panel, for bringing this forward. I think you recognize the importance of child welfare on this bill. I see that a similar bill was introduced last year in the House and Senate. How far did they make it?
I didn't make it very far, but
Did they
we're
get
hoping this year will be a little different.
So they died in committee?
I believe so. I don't have the legislative
I think
history
that's right.
in me.
All right, thank you very much.
All right. Okay. Are there any other questions for this panel? All right. Thank you all very, very much. We have one person testifying in opposition. It's Mr. McAvoy. He is supposed to be on virtually. He's coming in. Okay. We'll hear from Mr. McAvoy for 2 minutes when he gets on.
Thank you, committee. Appreciate your time today. I'm asking for an unfavorable on this bill. I testified on it last year. As you see the bill, it says, unless as a result of the use of cannabis, the child's health or welfare is harmed or placed at substantial risk of harm, or suffers, goes on line 19, suffered mental injury. I appreciate Delegate Tomlinson's point. DSS was called for a reason. It's the point that I made last year. Barbara Robinson, former Senator Barbara Robinson, actually had an issue with DSS not being aggressive enough, looking out for the child's welfare. So you might want to look into, she has a blog on such things. The de facto issue of harm is issues that this very horseshoe heard last year, where people testified in opposition to HB 0001 and 837, which is moving on track for legalization, because of doctors, emergency room doctors, talking about neurological brain issues, addiction issues from the super powerful THC products, which you heard about from a sheriff earlier this week, 90+% THC. They're not even going for crack anymore. The children are always involved, the secondhand exposure with these things. I want to say on Northern Parkway in the city, just last year, I passed a car with 2 women in the front smoking weed and saw 2 in the back, one with a school iPad doing homework. These children were exposed to a fog, giving them no air. I want to close by saying that I used to work at DJS, 300 North Gay. There's a file room full of drug cases. where mothers primarily wouldn't even show up to attend classes to get children back. This is an ongoing issue. I strongly urge an unfavorable, and I'm here for questions as well.
Are there any questions for the witness? Seeing none, thank you very much. That concludes the testimony on House Bill 232. We're going to go now to Delegate Long, who is here and will present House Bill 203. He's testifying in favor. There are a couple people who are going to testify in opposition after he's done. So Delegate Long, whenever you are ready, we will begin this second bill.
Thank you, Mr. Chair. Thank you, Vice Chair, and the members of this esteemed committee. This is a great-looking committee. I only say that here. Anyway, for the record, I'm Delegate Bob Long. This bill, for the record, I'm Delegate Bob Long, here to testify on HB, hold for a minute, let me get myself situated here, HB 203. This bill is reporting arrest and student alterations. What brought this legislation that I wanted to present to be drafted and to hopefully get passed is we had a student at Parkville High School that actually had raped a young lady. He's 21 years old, and by law, he's still allowed to be in school at 21. Raped a young lady, and when he was charged, they found out that there were several other people that he had raped. The principal failed to do anything with this student once she was notified. He was allowed to come back to school, and after that, this student raped two other students. It was on Fox 45 News, on all the news channels. Actually, we dealt with that with legislation about that particular incident. And we need to make sure that our schools are safe. If we have some of the heinous crimes that are committed by some of these students returning to school without the schools actually notifying, or the principals or the state's attorney or the Center for School Safety, it's alarming. We need to make sure that everyone's aware that if a student was outside and just robbed a bank with a handgun, there's all kinds of different, they're bad offenses, drug-related, drug crimes as far as selling drugs, gang relations. There's a whole list. It's laid out in there. A lot of heinous crimes, and that's what this bill is attempting to do, is to make sure that everyone's aware of it, that a student doesn't move from one school to another and they're not notified. And that is what the gist of this bill. It's a pretty simple bill. Just want to make sure their schools are aware of what's going on.
Okay. We will take questions. I see you, Delegate Kaufman.
Thank you, Delegate Long. It's very nice to meet you. I have a question, and that is, before you put this bill in, sir, did you consult with special education advocates or the special education community? The reason that I ask is that there are students with emotional disabilities that, as a result of the consequence of, as a manifestation of their disability, they will sometimes, because they have emotional disabilities, hit or kick their teachers, and they often have what's called a manifestation hearing to see if it was a result of their disability. And so I'm just concerned about special education students getting caught up in your bill when it's a manifestation of their disability. And I also thank you for sharing the story about the serial rapist. It's a troubling story. But how common, do you have any data about how many serial rapists are in school? Or, because they're always unfortunate stories. The news loves to cover bad news. I'm just trying to see if it's a common thread here.
Right. Your first question was about school, about students that have emotional problems. This doesn't deal with this unless they're outside, they shoot someone, they rape someone, or very heinous crimes. And that's what this bill addresses. And also, no, we haven't gotten more information. Thank goodness we haven't. But just thinking about what happened to the 3 young ladies that were raped by a 21-year-old student without anyone knowing about it, that's unconscionable. If someone would have maybe knew that this man was still in school, and I call him a man because he was 21 years old and doing what he was doing, we could have saved 3 young ladies' lives that are going to be ruined for the rest of their lives. And I would rather play it safe and make sure that we're on the right side protecting our children while they're in school, and that's what this is all about. And thank you for that. Thank you for those questions. Hopefully I answered them. Thank you.
Quick question. In the circumstance you're referring to where the individual was 21, what was the age when he was perpetuating the initial sexual assaults that you referred to?
I believe he was 21 because I believe state law says that they're allowed to be in school up until the age of 21, and until I guess he reaches the age of 22, he would have been allowed in school. I can't give you the exact age he was, but I know that he was a young man.
I think the point I'm trying to get to is we're talking about a 21-year-old ultimately. And, obviously below the age of 17, those records are going to be sealed. You're not going to be able to get their name. But certainly from 18 to 21, if he was committing that and you're saying he was a serial rapist, that information will be on case search. So I'm just trying to get clarity on in the circumstance you're referring to. If he's a serial rapist, then certainly that information would be easily accessible online in Maryland.
Right. Well, at the time that he committed the crimes, he was not charged. What happened was a young lady come out and said that she was raped. At that time is when it opened up, what had happened to her and to the other students. The principal knew about it, knew that he was, I'm sorry, wait a minute, let me get back. No, when he was charged, the school was not, the principal was notified. She did not notify anyone else in the school. So 2 more incidents prior to that had happened. And Delegate Grammer, he's very aware because we work hard to make sure that that never happened again, but we want to make sure that these arrest records are confidential, for one, and 2, that our school board and our school superintendent and our SRO officers are aware that if we have a student out here that's playing with guns, shooting at people, whatever, we want to make sure that the SRO officers are aware of that. And that's why this bill was brought forth. We want to make sure that our schools are safe. If a student...
I think I get that.
Okay.
Again, the clarifying piece is we're talking about somebody who for 3 years has been an adult under the system. And the characterization in the example you referred to, I'm just trying, you said he had 2 prior offenses. So I'm asking specifically, do we know how old he was for those offenses?
Right.
For clarity as it pertains to this example and as it relates to this bill.
Right. I don't have that information in front of me. I would be more than glad to get that to you. And I understand your concern. If a 12-year-old's out here with a 9mm gun shooting at people and he's arrested, and the state's attorney should notify the school and the school superintendent and anyone that needs to know.
I think the law already provides for that part.
Well, yes, the superintendent, but my concern is that if that student would move from school A to C, are they going to know about it? And we want to make sure they definitely know about what's going on. And that's what this is about.
No more questions. Thanks.
Thank you.
Thank you, Mr. Chair.
Any further questions for the delegate? All right, seeing none, we thank you very much.
Thank you.
There are 2 people signed up to testify in opposition. Maddie Long and Mikkel Gross, both here. We'll hear from each of them for 2 minutes, and then we will take questions and move on. Who would like to go first? Okay.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the Judiciary Committee. My name is Maddie Long, and I'm a Policy Fellow with Strong Schools Maryland. We are committed to ensuring the full funding and faithful implementation of the Blueprint for Maryland's Future. As a member of the Maryland Coalition to Reform School Discipline, we support making discipline responsive to student behavioral needs, fair, appropriate to the infraction, and designed to keep youth on track to graduate. This bill does none of that. Currently, school districts can remove students from school for indefinite periods of time when students are arrested off school grounds. This can occur even though the alleged offense has nothing to do with school. MSDE data shows that in 2021, Maryland Public Schools suspended Black students disproportionately so that they represent 42% of all suspensions, despite being just 33% of overall student enrollment. If we require additional reporting of student arrests to state agencies, we are opening the door to more stigma and educational barriers that Black and brown students must endure. Not to mention the further invasion of student privacy. The Blueprint for Maryland's Future unequivocally does not share House Bill 203's vision of a harmful information sharing system of public schools in the states. We do not get to world-class schools through creating additional barriers and marginalized communities. Strong Schools Maryland values justice. We believe the systems impacting our state students must treat them justly so they can thrive. All energy spent preserving injustice within these systems is wasted at a direct cost to students, their school communities, and society at large. We urge you to reject this bill and request an unfavorable report on House Bill 203. Thank you.
Good afternoon, Mr. Chair, Mr. Vice Chair, and members of the committee. My name is Michal Gross, and I'm an assistant public defender in Southern Maryland. I represent youth in juvenile and in adult court, and I am here today testifying in opposition of HB 203, which proposes expanding the reportable offense law. Section 7303 of the Education article, the reportable offense laws, is one of the most extreme collateral consequences when it comes to youth involved in the justice system. It denies them their rights to an education. Under the reportable offense law, students can be removed from school based on mere allegations. They're sent to an alternative school that might not offer the classes that they need, such as advanced placement classes or special education services, and they are not allowed to participate in extracurricular activities, such as student government and athletics. Other times, when an alternative school is not available, students are sent home where they're provided with worksheets and sometimes meet a tutor once or twice a week at the library. HB 203 is asking to expand this harmful practice and essentially start a database that would follow these students around without any connection or any nexus to public safety. And I heard the situation that Delegate Long had mentioned, and I don't believe that that situation could have been prevented by this bill. And there's no assurances within the bill about compliance with federal education privacy law. All of this based on mere allegations, entirely unrelated to school, for charges that may very well be dismissed. Last year, the Ways and Means Committee passed a bill that expands the data collection on reportable offenses. I know the Vice Chair is very familiar with it since he sponsored that bill. That bill will collect data. We don't have it yet, but what I can say anecdotally is that we at the Office of the Public Defender have observed the disparate impact of the reportable offenses law, the disparate impact on students of color and students with disability. The reportable offense law is complicated, and there are quite a few more details in our written testimony, and I'm happy to answer any questions, but I would ask the committee to issue an unfavorable report on HB 203.
Thank you. Are there questions for this panel? Delegate Simmons, then Tolles.
Just a couple of questions just revolving around assault, and how do you look at it when it comes to students? Scenario number one, kids, it's snow, so they have school. Now they take a snowball and another student throws it and hits another student in the face. Would that be considered assault?
Sounds like the definition of assault to me, yes.
Okay.
It could
Two
be.
other students now are inside the school and they're in the bathroom and they're slap boxing and somebody get injured. Is that considered assault?
It can be assault depending on the
Okay.
situation.
As we skip ahead to special education and students with IEPs, disabilities, and special needs often have involuntary body movements, which a lot of teachers report of being injured while at work. Are those considered assaults?
They can be. They all can be technically within the definition of second-degree assault.
Thank you.
Thank you, Mr. Chair. I know that you are the Office of Public Defender, but in your professional opinion, I don't see a position from the State's Attorneys Association. Where do you think they would be on this, considering that they would now be part of a group that they would have to report to, that they're in this bill? What is your thoughts?
I can't speak for the State's Attorney's
Sure, I know.
Association.
I'm asking what do you think they would be, based
I-
off you working with them, obviously, on the other side. But
Right. So I can't make assumptions, but what I can say is that quite often these situations are actually charges that don't even make it to the state's attorney's office.
Okay.
Quite often, there's charges that are dismissed at the intake level, never go forward to the state's attorney's office, and even if the state's attorney decides not to petition the case, the student is still removed from school while waiting for that to happen, and only if there's communication is the student actually returned back to school. And so this expansion is not designed to, it might be designed to, it might be intended to keep our students safer, but it wouldn't actually function in that way.
Thank you, Mr. Chair. Thank you.
Thank you, Mr. Chair. So I am familiar with the case in Parkville High School, and there's some cases in my district this applies to as well. In Parkville, the girl was raped. She came out publicly. It came out that the principal was aware of the sexual assaults. And then 2 additional female students, it came out and said, we were also raped by that student. So that, I get the arguments about what is assault, but that's not like slap boxing. That is actual rape. And the problem with this is this kind of thing is chronic, and it happens all the time. And not only do they not report it, they certainly don't file a charge, but they frequently sweep it under the rug. Tapsco High School in my district, there was a case of repeated offenders where they would take students who were gay, and they would literally chase them around the school with the worst pejoratives you could think of, and they didn't even tell the parents. So when you have, like, this is completely toxic, this is completely uncalled for, this isn't like a case of like squirting somebody with a water bottle and that's assault. This is far beyond that. This is the reason parents are pulling their kids from public schools. I don't know about this bill or an amendment or whatever, but isn't there, aren't the real marginalized people the victims in these cases? Isn't there a path for reporting these kind of things so you don't have a repeat rapist in a high school?
Delegate Kramer, I understand your concerns for the victims in those situations, and those sound like horrible situations. However, the reportable offense law wouldn't actually cover those situations because those are all situations that occurred within a school building. And reportable offenses are specifically about offenses committed in the community. All of those offenses that you're speaking about would be and should be covered by the school discipline laws and wouldn't actually be subject to the reportable offenses law.
Sure.
So I understand the concerns. This is not the right way to get there.
And I get that. And I have a reporting bill of my own. I just wanted to make the case that you can't just chalk this up as these are crimes that they may throw out. Like, these are clear, chronic crimes. They're happening every day. The school system is totally ignoring the problem, and students are just living in hell due to it. So, but I appreciate your comments.
And what I would say is that for every one situation like the one that you described, I know so many more situations where a student's been removed for a mere assault that happened in the community, that may have been a mutual affray, that may eventually be dismissed because that's what happens amongst kids. But that student's also removed from school, and removed from school without access to education. I've seen an 11-year-old sent home with just worksheets. An 11-year-old can't do worksheets on their own. They can't be left home alone all day while their parents are at work. So for every situation where a response might be necessary, there's so many other situations where students are permanently harmed, their education is permanently damaged by the reportable offense law and its overreaching capacity.
Okay, thank you.
Anyone else?
I think I'm on, Mr. Chair.
Delegate Pasteur was thinking about it, then decided she was going to go ahead and ask her question anyway. Delegate Pasteur.
So the problem here, so I want to ask this question of you. The problem starts with the fact that very often school administrators are not apprised of what happens in the community. The children do come back to school as they should because we're talking apples and oranges here. So if they haven't been adjudicated, then they're still out there and they're still eligible in all sense of that to come into school. Is that correct?
No, that actually is not correct. The reportable offenses law applies from the moment that a child is charged. And so even if they're not yet adjudicated delinquent, even if there's been no finding of guilt, no due process, they're still removed from school while that case is pending. And because this is just a charge by a police officer, it can take months. And in fact, the case can just end without any formal petition by the state's attorney. And that student would be out of school the entire time. that is happening.
Okay, well, let me just say that for double digits numbers of years, I was a school administrator. And the children did more often than not come back to school so they could get their education, all right? Whether they had gone to adjudication or not, they did come back to school. In the case that was described here, the child was not back in day school, that the principal made the decision to have the child in evening school or an after-school situation. The issue I have is that we don't ever want to lump all of the children into one basket. That in the bill or some bill, there should be something to indicate real communication between what is happening outside with the children and what goes on inside, so that a fair and just decision can be made about what is appropriate, not just for that child, but for all of the other children in the school. Often that doesn't happen, and that is the problem. So in this case, I don't know the principal, but having been in Baltimore County, I'm going to go with the notion that she thought putting the child in an after-school program when all of the children were gone, that would have given this child an opportunity, or a young man, the opportunity that by law he was entitled. And I've had students in the building who were 21 years old, but to still get his education, but be away from the rest of the students. I would just hate to see, and I'm asking, is this what you're saying, or is this your concern, that we would lump that situation into all possible things that students might do, which might be what Delegate Young was asserting, that we just sort of lump everything and then remove the children from school to do what? I'm not sure what, but to at least have the kind of communication, and that's the kind of law or bill. Is that what you're affirming here, that we need to process our children as individuals?
Yeah, I think that's some of the problem, is that the reportable offense law as it stands right now is overreaching. The list of offenses does include rape, but it also includes second-degree assault. And many other situations that don't necessarily pose a risk to the other students at school may not have anything to do with anyone at school. But the principal is notified. And once the principal is notified, it depends on each administrator. And one administrator may take a look at that situation and say the student can be safely maintained in the school, no reason to do anything. But another administrator may just decide unilaterally every child with a reportable offense needs to be removed from school and sent home to do who knows what.
That becomes the problem then, because it then ends up, there's no standard. So it ends up being at the discretion of the individual person based on the information they were given, which is generally limited.
And the problem with this bill is that it's not even just discretion, it's automatically reporting every single student who is arrested on a reportable offense, so that they're put in some sort of list, some sort of database maintained centrally in the state of Maryland by two different agencies, regardless of what they're charged with, regardless of whether or not it poses any public safety risk. And so that's the exact concern that you're worried about. Not looking at each case individually, this bill would mandate reporting to some sort of centralized statewide agency.
Thank you.
Thank you, Mr. Chair. Trying to get some clarity on some things I just heard. Is it true that under this bill, in the example that we heard, the principal would have been notified if this bill were law?
So I can't speak about the specifics of any case, but what I will say is that when a student is charged with rape, that would be one of the reportable offenses that a principal would have been notified about if it happened in the community.
I appreciate that. Is it correct that I heard that the principal was notified or had knowledge?
That I'm not familiar with the specifics of the case. It sounds like there's some delegates on the committee who might be more familiar than I am with the specifics about what actually happened.
I appreciate how, how you're responding, but I think, just to be clear, I think we did hear that, right? And it is true, I think, that it didn't stop what happened correct?
Like
I
I said,
know.
I
I
can't
know.
comment on the specifics of a case that I don't know anything about.
I just wanted to make that sure that I was clear on what I heard, which is this bill would have required the reporting to a principal. The principal had knowledge, and yet the incident still occurred and was not prevented. So, listen, I'm from East Baltimore. We deal with the types of things that the delegate was referencing. I'm looking for real solutions for what's going on in my district. Not rhetoric, not, I understand where y'all coming from, but bring me an example that actually worked. Don't bring me an example where I don't get the specifics on what happened. Don't bring me an example on the bill would do exactly what happened and it didn't work. That's going to cause me to vote red. No further questions, Mr. Chair.
All right, Delegate Valentine, then Tomlinson, then Simmons.
Thank you, Mr. Chair. I just have a point of clarification in your testimony, and thank you for coming in today. Because I wanted to clarify this, because I think I heard two different scenarios. For the reportable offense arrest outside of school, I believe in your testimony earlier, and correct me if I'm wrong, that the example was that upon the arrest, that child was then removed from school and could not come back into school until the case was adjudicated. And then I thought later that it was quoted as in your testimony that that would be up to the individual administrator from school to school. So I'm trying to determine which one of those that is.
So the answer is it's really both. The reporting happens at the time of charging or arrest, whether it's a paper arrest, whether it's a physical arrest. That's the point of reporting. So that's the point at which a child would be removed from school. Now, there is no part of the 7303 of the education article that says that a student must be returned back to school once the case is adjudicated. I will say from my experience, quite often that's all that the school needs is the case to be adjudicated. Even if the child's found guilty or involved in juvenile court, they'll send the child back to school. But that's on a case-by-case basis. That's not within the reportable offense law as it's written right now or as this bill would propose amending it. 7303 says that the point of reporting happens at arrest, not at adjudication. And so what you end up having is the law is applied differently across the state. So one school district may not remove students based on reportable offenses. Another school district may look at each individual case and determine whether or not this student should be removed, whether or not there is a public safety risk. And another school district may very well just remove every single student. There is not very much structure to the reportable offenses. There's not, the bill last year did establish more of a timeline and establish a lot of due process rights for the students before they're removed, but there's still no definite point at which they need to be returned back to school. And so you have it disparately applied because it is so discretionary.
Thank you.
Thank you. You mentioned at the beginning of your testimony, you mentioned blueprint, right? Or
Well,
you
for
did,
that,
sorry. But blueprint's my trigger word today.
No.
No, so I'm having a hard time understanding how this bill ties into the success of a blueprint. Can you kind of?
Yeah.
Okay.
So my organization is sorry, let me start over. We are very dedicated to ensuring that the integrity of the blueprint, the whole idea around it was to bring equity to our schools. This involves school reporting. So really, we just want to ensure that the ideas of the blueprint remain in our schools.
Thanks.
I just wanted to back up a little bit, just pertaining to sexual assault and reporting of sexual assault. So if a parent decides that, or their kid goes home and tell a parent that somebody felt on them or did anything that would consider a sexual act, they themselves can also press charges against a person. Is that action reported back to the school? If a parent outside of the school goes to the police department and filed charges.
Can I ask for some clarification on the
Sure.
question? Are you talking about a scenario that occurred at school and is just reported after
Right,
school?
so it occurred during the school day. Now the parent is home after work, and the student, male or female, tells the parent what took place, and the parent feels that it rises to the point of notifying law enforcement at that time. Is law enforcement required to tell the school once they initiate an investigation?
I think the school would have to be involved in that investigation no matter what. That situation, because it occurred in school, the student is likely to already be removed because of the school discipline regulation. And so it doesn't have to fall within the reportable offenses law because it happened within the school and the student can already be removed. There will be a separate proceeding, either a juvenile court or in criminal court, depending on the age of the student. And you know, as that process happens, the student is not likely to be in school regardless because of the court process, because of the school discipline process. The court process, the judge can actually keep the child detained or put a restriction on the child's attendance at school if there's concern about public safety if that child were to return to school. So there's many different other mechanisms in place. Reportable offenses is specifically addressing behavior that happened outside of the school.
Okay, so I guess my additional question would be, even though there's no proof of the incident happening, other than both of them saying, I didn't do it, or whatever the case may be, is there still action taken based on the fact that there is a police report filed? So there's a police report filed with the victim's statement, but there's no proof that it took place.
I think it depends on each school district.
Okay.
Some school districts may do a case-by-case analysis and, you know, realizing that this is a situation where it's just one person's word against the other, may say the student can still attend school. Maybe we'll keep these two students apart just to avoid any further problems. But that would be within the discretion of the school. That's actually, it's not really a reportable offense situation. That student can be charged, and as a result of those charges can be removed from school. As a result of the school discipline process can be removed from school. But I would hope that the school would would analyze that situation on a case-by-case basis.
All right, seeing no further questions, we thank you very much, and that concludes the testimony for House Bill 203. We're now on the third and final bill of the afternoon. It's the first bill of a new member of the legislature, carrying with it an enormous amount of pressure. House Bill 174, Delegate Simpson. It's Delegate Simpson for 3 minutes, Lisa Jordan for 2. We'll hear from both of them. There's no one else signed up to testify. So we'll have to carefully review this legislation. All right, with that, 3 minutes, please, Delegate Simpson.
All right, good afternoon. Thank you, Chair Clippinger and fellow members of our Judiciary Committee. So I am eagerly requesting a favorable report of our House Bill 174, which is the Victims of Sexually Assaultive Behavior. This is a constituent bill. This is a bill that was brought forth by Delegate, who is now a Senator, Karen Lewis Young, based on an individual who came to her that had that reported a sexual assault and then heard nothing. And so, of course, made it difficult to continue on with their life, knowing it was just kind of in hold. And so this is where it was born out of. And so I believe last year, and it might even have been a year before, but last year it got out of the House, so it got out of the committee and went all the way to the Senate, and then that's where, well, who knows what happened there. And so what this bill does is, in short, is a communication bill, right? We understand there are individuals who are very good at communication, and so those state's attorney, it's not going to make a difference if they are already doing this behavior. It is going to make a difference for those who may be a little challenged with communication, because it is going to require them to meet with the victim or the victim's representative upon either the victim's request or they would also need to meet with the victim if they are planning to drop or not pursue the case and to explain that justification to them. Why is this important? Because, as we know, it's not just the assault in and of itself that is traumatic. It's also the entire process of reporting that and seeking that justice. Some people like myself may have jobs that have very busy schedules and may be putting a lot of things on hold. It really is a bill that really helps a victim become a survivor by going through this process and having the communication and making sure that they understand what's going on at each time. I ask you for a favorable report. I humbly request a favorable report. Thank you very much for listening to me for my first bill.
Thank you, Mr. Chair, Mr. Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in support of House Bill 174. Thank you, Delegate Simpson, for your leadership in this area, and congratulations on your first bill. As you've already heard, this is a bill that would simply mandate that if a prosecutor decides not to go forward on a sexual assault case, that they communicate with the survivor about why. And although it was described by your esteemed colleague as a constituent bill, I'm very sad to report that this is a problem that we continually run into across the state of Maryland. Now, keep in mind for context that for every 1,000 sexual assaults, 9 of them make it to the prosecutor's office. Some aren't reported at all, some don't make it from law enforcement to the prosecutor, but only 9 of them make it there. And at the Sexual Assault Legal Institute, where we see over 400 sexual assault survivors annually, almost all of them have some question about the criminal justice system. And I'm sad to say that we hear all of the time that I reported, I had a rape exam, I did all of these things that people tell me I'm supposed to do, and I've heard nothing. And so it seems like this bill should be unnecessary. However, I unfortunately believe that it is. This did pass the House of Delegates last session, 132-7, and came out of this esteemed committee 17-3. So we would ask that this committee once again issue a favorable report on House Bill 174.
Are there questions for this panel? Quite a few questions all of a sudden. My goodness. Delegate Grammer, then Young. Oh, never mind. Delegate Young, then Conway, then Crutchfield perhaps, then Embry, then Phillips.
Thanks. I think it's a good bill, but I do have one question. Just in my time as a law clerk in the state's attorney's office, I understand that prosecutors have stacks on their desks like this. I'm sure our chairman does in his day job from time to time. But I ain't paying attention to my jokes today.
I am.
But seriously, so my question is, for instance, in Baltimore City, we have a victim witness unit. This bill requires for an assistant state's attorney. Would it be sufficient for someone that works in like the victim witness unit who can be familiar with the case to suffice in that circumstance as well?
So thank you for that question. I would urge this committee to place the control over that in the survivor's hands. And if they want to talk to the lawyer who made the decision, allow them the right to talk to that lawyer. Certainly, some people will be satisfied talking to the victim witness coordinator, but from your work, I know from my work, it's not their decision as the victim witness coordinator. It's the decision of that prosecutor. And, we ask a lot of rape survivors, and we ask them to help protect the community. The least we can do is have that decision maker talk to them.
So one clarifying question. My reading of the bill merely says a state's attorney with knowledge of the case, which may not be the decision maker. So I would just raise that in response, as if that's the goal, I don't know if that specific language reaches that specific goal.
Yeah, and that certainly was a compromise, working with the State's Attorneys Association. I don't know what they've said, but I don't think that any manager wants to be told what to do. So I appreciate that point, and certainly if you wanted to narrow that further, that would further the empowerment of survivors. As it is, MCASA is satisfied that having a prosecutor available would be sufficient.
Thank you very much. No more questions.
Thank you, Mr. Chairman. Thank you, witness, for coming out to testify, and delegates. So, Ms. Jordan, how currently is a victim notified about the status of their case?
We find that often they're not notified about the status of their case. If the case is actually in the court system, they can file a VINE notification system that will help them. Often when they're calling a rape crisis center, when they're calling the Sexual Assault Legal Institute, this is one of their questions, is that I don't know what's going on. And so that's what we're doing. We're checking case search. We're trying to track down an officer. We're trying to track down a prosecutor. That's what this bill is doing, is saying you need to communicate with the survivor. But some of them don't even get a piece of paper saying your case is dismissed.
I'm trying to be a little bit more specific. How long might someone not have knowledge of their case? I mean, once it's in the system, are we talking 3 years, 7 years? Maybe they never get an answer. They don't get a null-pros notification. They don't get anything?
Some of them have not received any information. MCASA currently houses the Sexual Assault Kit Initiative, where we're contacting over 6,000 survivors who had untested rape kits, and it's remarkable. Some of them years ago had a rape kit, and that was the last time they heard from anyone.
And I believe we still have rape kits that are untested. Am I correct?
You are correct.
Thank you very much.
Thank you, and thank you, Delegate Simpson, for bringing this bill. I appreciate it. I just want to make clear, as I'm reading the language, the meeting is only triggered if the victim requests it. So there's no notification requirement in this bill. Okay.
Correct.
Which may be a good thing, but.
Yeah, I mean, it certainly reduces the workload and the concerns that Delegate Young was raising. So this would only be if someone asks, and it also allows it to be in person by phone or by Zoom or whatever, if they agree to that.
But as you talked about, if the case is never charged, the victim may not know a decision has been made or not, so they're still.
Right, but they could still then request
Got it.
that communication.
Thank you.
I like this bill, and I'm supportive of the bill. But I have a question, and it goes beyond this particular situation. And that question really relates to anyone who has experienced trauma as a victim, receiving some ability to get an answer as to what has happened with their case. And I just strongly believe it shouldn't be strictly limited to persons who are affected by sexual assault. So I needed to make that comment. Because I've watched people go through victims of whatever kind, heinous assaults, right? And state's attorney's offices decide because it's an assault, person survived it, and they've decided they're not going to prosecute that case, and those individuals don't know what happened, right? So I love this bill. I just think it needs to be expanded.
Thank you, Delegate Phillips. Actually, that was something that was brought up by my local Hartley House. Inga James, called me and said, why don't you expand it, to, of course, we were already at this point, so it was very recently, had said, why isn't this for all victims of violence? So I do appreciate it.
Thank you.
Delegate Conaway.
Thank you, Mr. Chairman. Ms. Jordan, thank you for letting me revisit you. Under this bill, could a person ask what the reason was that their rape kit was not tested, or what were the results of their sexual assault kit, and find out if it was tested or not?
So thank you for that question. There's actually another section of the Criminal Procedure Code, and I could be off by a number, but I believe it's 11926 or thereabouts, and that has an entire process in order to provide survivors with information about their rape kits. Additionally, the Saki project, I'd be happy to provide that information to the whole committee. There is notification at umcasa.org. They can ask for information. We will help walk them through the process. And there's also a hotline that people can call.
Thank you. Could you contact me in reference to that?
Absolutely.
Are there further questions for this panel? My last, only, I think, question. Ken, you've worked with the State's Attorneys Association, so as I remember it, this is a compromise that we came to last year with the State's Attorneys Association.
I don't believe that they were fully enthusiastic about the bill, so I would have to defer to my colleagues.
They're listed as favorable,
They're-
but with a written statement, so I.
Very good. They're favorable.
That's what it says, so.
Yeah, there are several organizations.
That's fine.
that
I will say, going to what Delegate Young mentioned, an assistant state's attorney with knowledge could be somebody who had the case before, and then they get moved to another division. But having said that, I think that the underlying intent is pretty clear that the person who's working on the case would be the person. So, okay. For those watching this legislative history down the road, here you go. All right. Seeing no further questions, congratulations to Delegate Simpson on her very first bill hearing. And that concludes the testimony on House Bill 174, and surprisingly, concludes our bill hearings for today. We will be back on Tuesday, I think at 1 o'clock, sometime around 1 o'clock probably. And we'll have bill hearings again next week. Again, warning the committee, next Tuesday is a long day. Next Tuesday is a long day. How long? Don't know. Depends. But there are 14 bills, so we're expecting quite a few witnesses, so just keep that in mind. With that, we are adjourned.